Hello, everyone. Welcome to our second webinar on constitutionalism, trade, social justice, and sustainability in the Americas, lessons from the 2020 global pandemic. I am Elizabeth Trujillo, professor of law at the University of Houston Law Center and founding director of our new initiative, Global Law and Policy for the Americas. Today's webinar is on the impact of COVID-19 pandemic on international and global law, with guest speakers, Professor Rene Urureña from the University of Andes in Bogota, Colombia, and discussant Lorenzo Casini from IMT School for Advanced Studies in Lucca, Italy. The panel is moderated by our co-organizer of this webinar series and collaborator, Professor Sabrina Ragone from the University of Bologna and its Center for Latin American Studies. As I mentioned last time, GLAPA is an initiative that provides a platform to examine issues of international and global law from the perspective of its intersection with local policy and governance. This webinar series reflects this purpose, allowing us to learn from this important historical moment of COVID-19 so that we may formulate better legal frameworks in various areas where the pandemic has impacted society. Last week's webinar on the COVID-19 and impact on social justice highlighted interesting points regarding the social inequities that this pandemic has magnified, not only in its impact around the world and on the Americas in particular, but also in the distribution of the vaccine locally. It provided a comparative perspective to these issues. Among the points made, speakers emphasized the need for improved institutional competency in handling emergencies, reconfiguring economic strategies to include less austerity and more disciplined spending to prevent economic fallout resulting from such emergencies, restructuring regulatory frameworks to better address public sphere fragmentation, and which reflects just how traditional public goods have changed and become more privatized over time. And this causes different responses to emergencies. We were left reflecting not only on the important role that lawyers play, but also courts in balancing public health policies with individual freedoms. The video and summary of this first webinar can be found on the GLAPA website at law.uh.edu/GLAPA. Today's panel will continue this conversation from the perspective of international and global law. I will let my co-organizer and moderator for today's panel expand on today's discussion. But first, I would like to thank her and the University of Bologna for their collaboration in this webinar series, as well as the American Society of International Law Latin America Interest Group for their co-sponsorship. Professor Ragone is the professor of comparative constitutional law at the University of Bologna and a senior research affiliate of the Max Planck Institute of Comparative Public Law and International Law in Heidelberg, Germany. Previously, she was a research fellow at the Center for Political and Constitutional Studies at Madrid and Autonomous University of Barcelona. She has held research and visiting professor positions in several academic institutions in Europe, Latin America, and the United States. Her extensive publications have addressed comparative law methodology and substances in Italian, English, German, Portuguese, and French. She's authored many books, edited many books, and has published over 90 journals, articles, and book chapters. And her latest book, published in 2020, is on parliamentary systems and economic crisis, changes to constitutional arrangements in Italy and Spain. So with no further ado, I will pass the baton over to my colleague and collaborator, Professor Sabrina Ragone.
Thanks a lot for the nice presentation. Thanks a lot for hosting this webinar series. I will just briefly introduce today's meeting and in particular introduce our speaker and our discussant today. So as Professor Trujillo has already mentioned, today's session is devoted to how the COVID-19 pandemic has had an impact on international and global law, and our panelists will walk us through the role that international and global law can play, could play, or cannot play within the pandemic emergency, touching upon some of the topics that we have discussed last 2 weeks ago, and also some of the issues that we will probably address in the following seminars. I'm thinking about inequality, social justice, international trade, and the protection of human rights. Let me briefly introduce our speaker and our discussant. Our speaker today is Professor René Urueña of the Universidad de los Andes. Bogota, Colombia. He's an associate professor there, and he's the director of research at the law school. He holds a doctoral degree from the University of Helsinki. He has been many, many times an expert witness before the Inter-American Court of Human Rights, and more recently, he served as an advisor of the selection committee of the Special Jurisdiction for Peace of Colombia. Our discussion today, we're very happy to have René and Lorenzo with us today. Our discussion today is Professor Lorenzo Casini, who is a full professor of administrative law at the School of Advanced Studies in Lucca, where he teaches global law and cultural heritage law. He also holds an institutional position because since September 2019, he has been serving as the chief of staff of the Italian Minister for Culture. And before that, he also served for 5 years as a law clerk of the Justice Professor Sabino Cassese at the Constitutional Court of Italy. He has been research fellow at NYU on several occasions, and he has published extensively in public law, comparative and global administrative law. Many of you may know him also because he's the co-president of the International Society of Public Law, ICONS. Now, the program for today is similar to the one we had 2 weeks ago. So our speaker will have around 20 minutes for his presentation. Professor Casini will have 10 to 15 minutes for his comments. Then we will give a couple of minutes to René to reply, and then we will open the Q&A. So please, everybody that is participating, remember that you have the opportunity to write your questions in the Q&A section of this meeting. I will be managing that section and asking questions at the end of the session to René and Lorenzo. So I would like to join Elizabeth in thanking both René and Lorenzo for joining us today, and I leave the floor to René.
Great, so thank you very much, and Sabrina, thank you very much for the invitation. Elizabeth, thank you very much. So it's an honor to be here, and so particularly because of the initiative that you're developing, the center. I think that's so. I think it's very, very important that our colleagues in the U.S. Start looking at the Americas as a whole. And I think that conversation is increasingly important. And I think that Texas is a key site to do that because of its Hispanic population, and also because of it really is a point of entry with Florida of a lot of the issues that affect so that in a way that affect Latin America and then spill over to the US and then go back to Latin America. So I think that conversation, so I really celebrate the creation of this center. And it is one of the things that if it didn't exist, someone had to create it. And I'm very happy that it was Elizabeth and Sabrina and people there at Houston. So really, I really wanted to say something about the center. I think it's an incredibly important initiative. So thank you very much for the invitation. And then Lorenzo, as always, good friend, thank you very much for agreeing to comment on this. So what I'm going to do is I'm going to talk about distributive justice, and distributive justice in the context of, let me show you this. All right, yeah, this is working now. Great. And then, so the idea is this. So it's my talk is called, or is entitled, we're not in this together. Inequality as the defining COVID challenge to international law. So two things that I want to say. So first, obviously, I am questioning the idea that COVID has an equal impact on all of us, that we're all in this together, and that we should, that the virus doesn't discriminate, and that we should fight this together. Well, we're not. And then we all know how we're not, and we all have seen the data, we all have seen the images, we all know what's happening. But then when we talk about COVID and international law, what we end up having is a discussion on the exceptions of COVID, the exceptions that international law allows with regards to COVID, so that you are able to create exceptions to human rights law, so in order to have people locked in their house, or that you're able to have exceptions to investment law or to trade law. But in a way, international law as such is really not talking about that issue, that very issue in terms of equality. And therefore, what I want to suggest is, and this is a work that I'm starting to develop right now, so this is why the comments will be so useful, is really how the defining challenge is really not a matter of cooperation in terms of institutional organizations. Is not really a matter of, in a way, a lack of enforcement of international law, but it's really a matter of inequality. And then we really go into a very key issue, which is that this is my argument in my talk, is that really COVID pushes us and pushes international lawyers, global lawyers, to take inequality more seriously. So as a normative commitment, as a doctrinal construct, and as a cognitive framework. So, and why is this so important? Because as I'm going to explain later on, inequality as a matter of distributive justice is really not considered that much in the language of international law, in the language of global law. And therefore, what we're saying with COVID is precisely that this is the key issue. So this is what we should be talking about. So this is the normative, let's say, a basic framework that we should be considering. So that's the argument. It's very simple. Basically, COVID is pushing us, international lawyers, to consider inequality more seriously. That's the basic argument. And then, probably in the discussion with Lorenzo or in the Q&A, I'm going to give some examples of how that could be done. So, but why? So why is it that it is so important to talk about inequality? And to talk about that, then I'm going to give an example. And here, this is something that this example, I'm building it on this, a seminal book by Henry Frankfurt, Inequality. And this is the example. This is a thought experiment that is very common in moral philosophy. So imagine, cast away, imagine a desert island, so on and so forth. And then you have 10 people. But you can only, so even though you have 10 people to feed, you can only feed 8 people because you only have enough food for 8 people. What does that mean? That if you feed if you feed the whole of the group, that is, if you feed 10 people, then there's not enough food for everyone, and everyone is going to die. But if you let 2 people die, then the 8 remaining people are going to survive. So the question is, how do you distribute the very scarce resource that you have? Do you allow everyone to die, or do you allow 2 people to die and then allow 8 people to survive? This is a very classical, so you see different versions of this thought experiment in very different works of moral philosophy. The normative, so what one would normally find the most standard answer in terms of equality is, well, for better or for worse, you should leave 2 people to die, because anyway they're going to die, and then you have 8 more to survive. And then the normative question is really, how do you stop these 2 people from dying? That would be the normative question. How do you create some way of, creating more wealth in society, bringing more food in or whatever, that this choice is not necessary? But if faced with the choice, then most moral philosophers agree that these 2 people would die. That is more or less the question then. Is so when it is framed in those terms, is then that the normative problem is not that resources are unequally divided, but rather that some members of society don't have enough. That's the question. So the moral question in this thought experiment is really that, so that when you have to divide, it's not that you question the way resources are being divided, it's rather that it is unfair. The ultimate consequence of the thought experiment is that it is unfair that these 2 guys that we have here, these 2 Tom Hanks here, these 2 guys have to die. That's the problem. And therefore, the question, or the normative question in that context, is then that what you should have is ways that you should create the point then normatively. So normatively, remember, in terms of what should be done, is not to equally let everyone die, but rather to find a way for the 2 to live. So that's more or less, so when presented with this choice, then normally a moral philosophy has 2 levels. Well, at least liberal moral philosophy has 2 levels. It says, yes, you could be utilitarian in the sense that you have to leave these 2 people to die. That makes sense in a utilitarian framework. But really the question is, we shouldn't be facing that consequence. The problem is not how would you divide the food, but rather that these two people shouldn't be left to die. And international law, in a way, international law understood as the legal language that, in a way, has implicit distributive, let's say, that adopts a specific implicit distributive framework, says, in general terms, I can explain this, why I say the international law says this, but in general terms, international law says, yeah, that is more or less the case. So the case really, so the problem really is really not how wealth is distributed. The problem is not about distribution. The problem is really that there are people who are left outside. States that are too poor, individuals that are too poor, and think about it in these terms. And this is very intuitive, but think about it in these terms. When we talk about inequality, us, scholars, students, we think about Jeff Bezos, this guy here who has recently retired, this guy here, and then, Jeff Bezos is 100 times richer than his labor lawyer, because his labor lawyer makes more or less $1 million a year, give or take. And Jeff Bezos is extremely rich, and he makes literally thousands of billions, literally. This is a problem of inequality, you see. So when we think about inequality, this is evidently a problem of inequality, in the sense that Jeff Bezos is, has much more income, much more wealth than his labor lawyer, who in turn is a millionaire. But that doesn't sound as morally repelling for us, you see? So you see, that's, yeah, it's inequality. But when we talk about inequality, we figure that the problem is that people have too less, that some people are left outside the game. And that is the way international law also thinks about this issue. In a way, when international law, in general terms, speaks of inequality, really they do buy into Frankfurt's overall description and prescription. So inequality under international law, and particularly under international human rights law, which is the most developed vocabulary to speak of these issues, really says is often invoked as a framing radical socioeconomic exclusion. So the problem when we speak of inequality is really a proxy in international law, and particularly human rights law, is really either to say that there is a problem of discrimination, so that's another issue, there's a problem of discrimination, or when, for instance, courts such as the Inter-American Court of Human Rights that have gone even further in terms of progressive case law, socioeconomic justice, socioeconomic rights, so on and so forth, they say that the problem is not that there is inequality, but rather that there is exclusion. So that there are people who have too little to eat. So people that have not enough access to education, to a minimum education, or this basic minimal standard of living. Meaning, when we think in terms of international law of inequality, we think not of distributive justice, but rather we think of inclusion of a certain group of people that are excluded because of the socioeconomic process. Well, that may imply some kind of redistribution. Yeah, so to bring people over, to guarantee certain kind of minimal standard of living, you may have to tax your way through subsidies, so on and so forth. That, in that sense, it is a distributive problem. But the problem as framed is not inequality of income as such. The problem as such is, or the problem that the way the problem is normatively framed is that some people are excluded, that some people should have access to the bare minimum. If, let's say theoretically, we guarantee that bare minimum, then there really is no problem at all that other people have so much. in those terms in human rights. So if, for instance, you do have access to health, you do have access to minimal education, so on and so forth, a bare minimum standard, such as, for instance, the Colombian Constitutional Court has adjudicated on, which is very, very progressive and is celebrated as very, very progressive. But if you guarantee a bare minimum, then really there's no problem that some people have 100, 200, 3 million times more than the lower echelons of income. That's really not then a normative problem for human rights and international law at zero. And why is that? So I have 4 explanations very briefly. Why is that bias? First, I think that for better or for worse, international law has, this is 4 bias, not 3 bias, but 4 bias. So the last one, I thought it more recently. So the first one is really that international law has in a way bought into this neoclassical economic bias. We were talking before of these horrible things that have happened in Texas because of deregulation of the energy markets. And that is also an expression of this neoclassical economic bias in the sense of thinking that there is this notion of the free market that is going to take care of distribution of assets of scarce resources in a society, and that way of let's say of assigning resources in society is efficient, and therefore that there is this division between distribution, that is politics, and efficiency, that is technical. And because the law is political and not technical, I'm sorry, because the law is technical and should not be political, therefore it shouldn't be too concerned with distribution. Distribution should occur in other contexts outside law, and in particular outside international law, because then you have the democratic deficit critique. These international courts shouldn't be taking the decisions. These are distributive decisions. This should go to domestic congresses, let's say, to national congresses, so on and so forth. First. So second, why is international law why is international law not concerned of income inequality in those terms? The second reason is international law's pro-court bias. So because when we think of international law as being very effective, we think of international law in terms of adjudication, then we think that when courts, courts are unable, let's say, to effectively adjudicate a lot of these distributive issues, particularly international courts, because of enforcement problems and because of the way in which they interact with domestic constituencies and authorities. And therefore, because we want to, in a way, as international lawyers, protect, or we want to protect the legitimacy of international courts, and we want to focus in what courts do, therefore we feel, or in a way, our way of understanding international laws function in international society live outside distributive justice or distributive concerns. Fourth is really an anti-revolutionary bias. Really, so really the issue, this liberal bias of tilting towards a transformation. I myself, I am of course also guilty of that bias. Much of my work is precisely on transformative constitutionalism, not on revolutionary constitutionalism, because then we have the bias. So we say, so the problem with distribution is that it also kind of invokes, particularly in the global South, this Marxist this Marxist rhetoric of strong, hardcore distributive justice ideas. And lawyers, particularly international lawyers, who believe, a lot of us, in this cosmopolitan liberal normative project, we say, yeah, I'm not that sure. I'm not that sure because, from distribution to class welfare is just a step, and I'm not too convinced of that. And that is a bias, that is a prejudice, and that is the third reason that I speculate would be a reason why international law is not that concerned with that notion. And then the fourth one is, for better or for worse, our skepticism on the notion of global justice. Regardless of all the human rights and global justice programs that we see in all US and European universities, the fact is that for better or for worse, much of international law is still built on this right, WRIGHT, this international relations scholar of the 1960s, who said basically justice is a matter of domestic politics. International politics is really a matter of survival. This realist take of the notion of justice. The idea, and Tom Pogge notwithstanding, the idea that there's something significant that can be thought of as global justice is really something that is analytically very difficult to grasp, because there is no global constituency, no global group of people, so no global demos that would share a certain moral agreement in terms of creating a moral community that could speak of a morality in terms of global justice. And particularly, this argument most often than not goes to the problem of enforcement. Is how can you think of global justice if we don't have enforcement, if we don't have an institutional machinery of enforcement? So do note that these four are just biases. You can find counter examples. You can find instances in international law when the neoclassical economic bias didn't play out. So think about the new international economic order. You can see instances where the pro-court bias didn't play out. Also, the anti-revolutionary bias also doesn't play out all the time. And we're reading extremely interesting Marxist international law scholarship today that would give us elements to think outside this anti-revolutionary bias. And of course, global justice, I've already mentioned some literature that questions this anti-global justice bias. Not anti-global justice in the sense that they think that we international lawyers think that global justice is bad, it's just that we think it's not feasible, let's say, that is not a relevant threshold. Well, so those are the reasons. So what we have up to now is two ideas, basically. International law is not that concerned about distributive justice, and that is so because international law incurs in these four biases. That's where we are right now. Along comes COVID. So the challenge of COVID, and I'm going to take 7 more minutes and I'll be done. So the challenge of COVID is precisely that, particularly with regards to the distribution of scarce resources. Remember in April 2020, the discussion on PPE, so on protective gear for and N95 masks. Then think of when certain treatments started being proven as effective against the worst cases of the illness. The moment when people start saying, no, you can't export, when the UK, for instance, said, you can't export these medicines, you can't export this PPE. Even within Europe, you had that discussion. And now, obviously, think of the vaccine. So that's obviously the case of the vaccine. So all these issues point to a problem of distributive justice. So the most pressing issue, at least right now, in terms of COVID, is distributive justice. And a very traditional classic version of the problem of distributive justice. We don't have to go too deep to see how this is a problem of how to more justly distribute scarce resources. And then underneath that issue of the general distribution of scarce resources, we see other, let's say, derivative, but crucially important sub-problems of distributive justice at the local level: gender, race, informality versus formality, so on and so forth. All these issues then play out in distributive terms. So when we look at, for instance, so I was reading just yesterday in the New York Times how a suicide of women in Japan peaked during the pandemic, while the general mortality rate descended. So people are dying less, but women are killing themselves more. For instance, obviously, I live in Colombia. the issue of formality against informality is evidently there. All these are distributive problems, and all these are distributive problems that in turn play out in a global sphere, in a global, let's say, landscape. And for the purpose of this talk, I'm just going to focus on the global landscape, and particularly in terms of interstate distribution. Why am I saying this? Because there is another layer to be discussed here, which is a distribution within the states, and also distribution among, let's say, transnational identities that are particularly affected. Let's say, people of color. So people of color are transnationally affected in a disproportionate way as compared to white people, let's say. So you could do also that, and that is also a question, a problem of distribution, and that I think would also fit into my framework. But for the purpose of this talk, I'm going to just talk about distribution of scarce resources among states. So the unit that I'm going to take here is among states, because here I'm going to talk a bit more, so I'm going to focus more on most, let's say, traditional areas of international law. Meaning, human rights, investment law, trade law, so on and so forth. There are other issues, Lorenzo, of course, an expert in global administrative law, that could be fed into this framework, but I'm not going to talk about these other issues of sub-state, let's say, or intrastate distributive issues. So then the third point here, the third point is, if we say that international law doesn't consider distributive justice, if we say that international law doesn't consider distributive justice because of these biases, or at least because of some of these biases, and COVID is really a challenge that I suggest is the main challenge in terms of distributive justice for international law. If that is the case, then how to start thinking about distributive justice in international law after the COVID shock? Let's say, how do we use, as international lawyers, as international scholars, this crucial tragedy that we're seeing, everyone is seeing, to push forward international law to consider international distributive justice? How? And then those are the, and this is my last slide. So how? I think that there are three levels in which we can engage. The first one is the overall normative commitment of international law. Such, I know, how can you speak of a normative commitment of international law? Well, we do it all the time, and I'll tell you later on how we do it all the time. I'm just trying to push that consensus towards distributive justice. So first, as a normative commitment. Second, in terms of doctrinal constructs that we use. So in terms of the doctrines that we create and advance through litigation, or also in terms of scholarship. And then finally, it's something that I have been working a bit lately, is what kind of cognitive frameworks we develop through international law to think of distributive justice at the global level. And then what I'm going to do is I'm going to give 2 or 3 examples of how to think towards the future. So the idea is how to frame this conversation, or how to engage with this conversation. So the first is how to start thinking in these terms. So the first one is, normative commitments. What do I mean when I speak of normative commitments of international law in these terms? Well, international law, either explicitly or implicitly, usually has certain normative commitments that are generally liberal, generally cosmopolitan, and they play out in a certain way of understanding the international community. This is precisely what critical international legal scholars raise their hand and say, this consensus overlooks imperialism. This consensus overlooks race or gender or whatever. But there is this, if you want, underlying, let's say, allegiances of a normative consensus. And basically the question here is the following. How come that this is actually the question that started this line of work for me, which is, if we can talk about international criminal justice, why can't we talk about international distributive justice? What is it that makes distributive justice so absolutely unfeasible, as opposed to the normative commitments that are built into the DNA of, for instance, something like the International Criminal Justice Project. So this is to say, I know this is a rhetorical question, but this is to say, how come we accept implicitly the notion that there is an inherent, or let's say underlying normative consensus that allows us to think that international criminal justice is a worthy program, but we say distributive justice is absolutely impossible to think of because we don't have a common demos, because we don't have a common morality. Yeah, we don't, but if we don't, then we shouldn't have international criminal justice either. And we do have international criminal justice, and we do have the institution. So that's just to say that
Rene, we also have a common schedule. You have a couple of minutes.
Yeah, this is the last thing. Excellent. So that's the thing. And then where to start from this? I think one starting point in terms of the normative commitment is the Sustainable Development Goals. For better or for worse, I know that they're hugely criticized, but the Sustainable Development Goals reflect a certain level of consensus in terms of governance and equality that connects with the rule of law. The rule of law and governance are there in the Sustainable Development Goals. So how come we don't connect with that? And that would allow us to a first step, let's say, in normative terms. Second, doctrinal constructs. Well, I already spoke of how we should go beyond the bare minimum standard, how we should really try not to, or at least try to think of different ways beyond the idea that the bare minimum is the only international legal standard that is relevant. And this, of course, brings us to doctrinally going beyond the rule exception structure that dominates all discussion on international law and COVID right now. And then finally, the cognitive framework. Well, the cognitive framework, what do I mean by the cognitive framework is what kind of idea, what kind of imagery are we pushing forward in terms of the international community when we're thinking about COVID? So we should redefine this idea of international community that really goes beyond, on the one hand, market integration, so globalization and global law as the law of the global market. And the alternative that we have is international law that is the resistance, is the law that is created by transnational civil society networks. Those are the two vocabularies, the two ideas that we have of the international community right now in international law, even when we go beyond states, no? So how can we think of different ways to frame, to consider, to develop an idea, an imagery of the international community that doesn't consider these two, or that goes beyond these two paradigms? What other ideas can we develop? Those are the three lines of thinking that I think would be useful. And then I thank you for your time. And so that's it. Thank you very much.
Thanks a lot. I would like to give the floor to Professor Casini for his comments.
I have my video blocked, so I cannot launch my video. I mean, it's like it's the host that blocked my video.
Try now.
Okay. There you are.
That works. Okay. No,
we can also see the flag.
Yeah, the Italian and the European one. Thanks, Rene. I will try in a few minutes to offer some perspectives on the relationship between global law, international law, and national law, because I think that the experience that all of us had because of COVID, behind the fact that it was tremendous and dramatic from many perspectives, really demonstrated that still states as political entities, then of course we can discuss the dimension, the size of state, the kind of state, but the state is still the master of the scene. I mean, what happened in front of a pandemic demonstrated, on the one hand, that states are still the main dimension, the main actors, But on the other hand, it was the evidence that state alone cannot solve any problem, especially if it is a pandemic. So it is a global problem. So I'm trying to focus on three aspects. So one is the role of international institutions, or role of international organizations. The second one is the harmonization of norms, of standardization. And the third one is related to human rights, and as you also pointed out. Now, in terms of the role of international institution, I was quite surprised in looking at the difference in the role of WHO this time in comparison with what happened with SARS in 2002. I think that this is something that will have to be investigated at some point. Probably now it's too early, but it is something relevant that this time the global institution was not so. I don't want to say effective, but was sometimes sitting a bit on the back and leaving the state intervening. Like in 2002 was the opposite, to the extent that the WHO then had to amend the international health regulation in order to have stronger instruments in order to face a new pandemic. So I think that somehow, if we have to consider the role of international institutions, the pandemic shows that states were stronger than them in fighting against it, on the one hand. On the other hand, if we consider regional dimension, think of the European Union, what was clear since the beginning for issues like data protection and privacy, it was inconceivable to have state intervention at the state level. So what happened, for example, in Korea, or what happened in some countries in Europe with the regulation enacted by a regional institution, so the European Union, there was no chance to have single intervention affecting data protection without confronting with the regional authority and with the supranational authority. So there was context where it was clear that you needed a supranational dimension, and the role of European Union on this was crucial. As it was crucial, for example, in terms of money, in terms of funding, in terms of finding instruments, as you said, to somehow overcome the inequality that you might have in different states. Second issue, standardization. So I think that for many aspects, probably not enough on the most important one, vaccines, but in many other aspects, global law and international law in general could be very useful, and is trying to be useful in offering standardization on many sectors. Think, for example, on tourism, on safety standards for traveling. Now the G20 will focus on the part of tourism to adopt guidelines that will be recognized by all states for safety travels, for safe travels because of COVID. Because you cannot now imagine that you have different rules, different norms if you want to travel from one country to another. We already have the passport. Now, if we introduce also different standards, so that you have to be, for example, with vaccine or not, or we have to bring with you the evidence that you are not COVID positive. So this is something that only a global level can be regulated. You cannot think of regulated at national level, otherwise there won't be any tourism anymore. So from this perspective, there are many fields, probably not global health as it should be, and this is connected to the role of the WHO that I was mentioning before, that global regulation can play a significant role. And then I go to the third and final point, human rights. Now, of course, experience were different state by state, in terms of how COVID spread, in terms of the number of victims, unfortunately, in terms of the measures that were adopted state by state. But what we could see, unfortunately, and this is something that I'm aware is happening in the United States as well, that the fight against COVID really increases the level, the degree of inequality within the state. So it's not only a problem, of course, comparing states amongst themselves, but it's a problem within the state, within different aspects in terms of incomes, in terms of geography, and there is also a huge issue of gender that the COVID really affected. I mean, I don't want to say that here in Italy, in some cases, we went back to middle age, because Elizabeth made me clear that we still are in the middle age here in Italy. So there was no chance to go back from them. But seriously, the dynamics of keeping people at home and having the problem of going to work, really somehow it was going back decades ago, and the state tried to implement measures to avoid this, and so to favor a gender equality, a gender parity, but this didn't happen. I mean, the family dimension somehow recreated the role of the woman that is not acceptable nowadays. So beside this, there is the theme that you were mentioning on human rights, that is how we should face all these new problem that is an old one, but for some states is a new one, in limiting so strongly fundamental freedom, and including the freedom of movement, including the freedom of doing something. That, you know, that there were problems of how we can really say that you have to be at home, that you cannot go out of your house, you have to be there. So that's a problem of constitutionality of such provision, no, in terms of limiting your movement. So one question that we will have at some point is how we will face this if someone will decide to go before a supranational court, a court for human rights, somehow demanding a sort of compensation, or anyone doing, including the damages that were suffered by such measures. So I try here to offer perspective additional to the theme, of course, of the vaccine that we had in terms of human rights. If we might talk about the right to be treated, a human right to be treated, a human right to be to receive the vaccine. But there is also a problem in how states not taking care of international law of human rights. They had to face the pandemic, and they enacted measures that were, if we look at the Constitution, quite difficult to be framed. Of course, there is the emergency power. Of course, there is the need to face the pandemic. So I do believe that that was the only measure. I mean, all the states basically chose the same way. But in terms of relationship between the Charter of Fundamental Freedoms and the administrative measures that were taken, there is a point that needs to be addressed. So in conclusion, basically what I will ask René to focus a bit more, if he wishes, and also according to our host, is how do you see, I mean, if you really see that COVID could be an opportunity for international law, or if again the evidence that states are still so dominant that international law is on the back. I mean, at the end, states are still the main player, and this is what the pandemic somehow demonstrated us. Thank you.
Thank you very much, Lorenzo, for these very comprehensive comments. As we have around 10 minutes to devote to the Q&A, I would add a couple of questions that we have in the chats for René, so I can then leave him the floor, and we also have a couple of questions for Lorenzo. So the first thing that we have seen in the chat is how do we ensure that the COVID-19 vaccine is accessible to all nations irrespective of their degree or of scientific and economic development? And the participant gives the example, for example, of Nigeria or countries in which we can truly see this growing inequality pattern that we were talking about. A second question is related to the rule of law and its role in international law. And so to what extent we can actually rely on international courts, as we are witnessing a retraction from the reliance on international courts. And the third question is related to the distributive justice perspective that René adopted. And the question is, how would a distributive justice framework help domestic governments to do better, or whether this is still a matter of the state, as Lorenzo underlined in his comments. And so it's the state that is going to define the terms of distributive justice, and then to these standards, international law will have to respond. I think this question is more addressed to both speakers. And then a final point on constitutional law, and I would say constitutional pluralism or constitutional comparative law, because every country gives a different assessment of these constitutional issues. And so what is somehow the interconnection between international law and constitutional law? I think I can give the floor to René first, and finally to Lorenzo.
All right. So thank you very much. Thank you very much, Lorenzo, for those very insightful comments. And again, thank you very much to Elizabeth and Sabrina for inviting me and moderating. So I'm going to just focus on three or four things very briefly. So the first one is the notion of the state. So, okay, so Lorenzo is saying, and a couple of the questions there were, so what COVID reveals is that these international institutions are really not that important at the end, or less important than would appear for the cosmopolitan, that in fact, the state is again the key player here. And I agree. So the state is the key player here. My question then, or rather, my concern or my intellectual agenda regarding the state here is the state as understood as an agent of whom? So who is the state an agent for? The question is this. So is the state solely an agent of its citizens? The state as a legal person, the state as a, let's say, ideological, economical, juridical, political, and military reality? Is it an agent only of its citizens? Because then the question is, because that is directly connected to the question that the colleague was formulating about Nigeria. How do we ensure that the vaccine is available to the states that have less income, let's say? Why? Because then the question is, how acceptable is a level here of national preference on behalf of states? So when Canada has enough vaccines to vaccinate 6 times its populations, I believe. 6 times, let's say in the long run. How justifiable is it that Canada decides to use those vaccines for its population, let's say to stock them or whatever? One would say normally, no, that's very unfair. They should share those that are there not being used, no? So there's a level. So on the one hand, vaccine nationalism is often criticized. But at the same time, some kind, and I'm just using the example of vaccines here to make my point clearer. At the same time, though, some kind of national preference is acceptable, more or less. So yeah, you should more or less vaccinate, obviously, your people first. And then the underlying normative question in that discussion is really, who is the state an agent? So who is the state acting on behalf of? Well, if you say that the state is solely, only, absolutely acting on behalf of its citizens, then the answer is there's no possible way to have a distributive justice framework in international law. But that is the idea that I was referring to before of our bias against global justice, that we say justice, of course, domestically, internationally, you know, is just survival, fight it out. But then we, of course, when we think of international human rights law, when we think of jus cogens norm, When we think of international criminal law, we say, no, states are not solely agents of their own citizens. They have a differentiated, of course, it's not the same, but some kind of differentiated normative and moral responsibility towards the, let's say, the whole population of the world as a whole. It's not the same thing, but there is there that let's say, that agency there. That's the agency, very limited. We could call it, let's say, following Grotius, a very, very weak sociability, let's say. But it exists. Therefore, if the state is not only agent for its own citizens, then we can have a significant normative discussion of whether states should, for instance, how should states distribute vaccines once they have fulfilled their a basic duty towards their own populations. Then that would be the question. That's the space, let's say, that I'm trying to fill with this theoretical conversation. So answering to Lorenzo, the question would be, yes, the state, but the state on behalf of whom? And the answer is not only on behalf of the citizens, but there is some level of, let's say, weak sociability there first. And that, of course, brings us to also and it's the same question with international organizations. And I'm just going to answer these two, and then I'll leave the floor to Lorenzo. It's the same question with international organizations, but with international organizations, we already have that. We already have a theoretical development to that effect, which is the critique of functionalism in international organizations. So this is Klaber's saying, we think that the principal agent model in international organizations say that states are the masters of the organization, and therefore all this debacle of the WTO, WHO then is explainable in terms of principal agencies. When Klaber say, in fact, organizations are not only agents of their member states, but are also have a responsibility to the wider international community. Otherwise, we can explain rules of immunity. Otherwise, we can explain, well, a whole set of doctrinal discussions in international institutional law. Here, the argument is exactly the same. International institutions, they also have a responsibility towards the wider international community in those terms. I'm going to close there. I'm going to give the floor to Lorenzo for him to answer the last two questions, and I'm done with that.
Thank you, René. Lorenzo, the floor is yours.
Thank you. Well, but I think that the main point is that probably there is no only one answer. there are many responses. So what I believe that the pandemic in its tragedy demonstrated is all the ambiguities that we still have in the relationship between states and international law on the one hand, but also in how states themselves see they see themselves, no? And this is so, I agree completely with René. The main problem is what do we mean by state, and so, what we are thinking of as an agent of whom. But what we have experienced is that somehow it wasn't the local authority at the end. It wasn't at let's say, another level of government. I mean, all the people then recognized themselves in facing the pandemics on the national leaders, I mean, good or bad that they were. And there was a clear identification in the national state. So this is something very important. There was an interesting study recently published on the because of gender, that basically that women did better in the pandemic, especially women leaders did better in terms of the role of New Zealand Premier or Angela Merkel, because of the empathy that they were able to communicate to the citizens in terms of response from that. But in that study, beside the conclusion of gender, was interesting how it appeared clear that there was an identification in the national state in facing the pandemic, much more than international law, international institution, or whatever. So I think that this is something that that bring interesting consequences in how still states are the political entity par excellence. No, so this is the fact that the pandemic demonstrated to me. Okay, I stop myself.
Thanks. Thanks again. Thanks to both René and Lorenzo for these very interesting insights that shed light on some of the issues that we addressed also 2 weeks ago. I'm sure that if we had more time, we could have a much longer discussion, but I know that we are already, 3 minutes late, and we promised everybody we would be on time. I will simply thank again Elizabeth, René, and Lorenzo, and leave the floor to Elizabeth to conclude, and also invite you all to the next webinar.
Thank you, Sabrina. Thank you, Lorenzo and René, for such an interesting, intriguing conversation and discussion on a very important topic. For me, some of the things that were most striking were just sort of having to rethink international law, that COVID is pushing us to rethink international law and its institutions, and thinking about it through a distributive justice lens and from a normative perspective, and what that says and how that changes not just international law frameworks, but also domestic frameworks. And frankly, to stimulate us to think more broadly about the foundations of international law from a moral philosophy perspective. Also the role of the state. I think this conversation really highlighted sort of this interplay between the state and the global, because the state is still the key player here, and trying to reframe international law from a distributive justice perspective, we see that the state has to play a very important role in this as well. And finally, some of Lorenzo's comments around harmonization of standards, the role of institutions, made me think about the role of administrative law, and how perhaps these legal frameworks will help us to sort of think of, to implement some of these distributive justice norms from an administrative law perspective. So thank you all. Please join me in thanking our speakers and Sabrina Ragone for keeping us on time and for leading the conversation. I want to welcome all of you also for our next webinar, which will be March 11th, which will be on the lessons from COVID-19 for sustainability, health, and climate change, with Professor Daniel Farber of Berkeley Law School and Pedro Villarreal from the Max Planck Institute of Comparative Public Law and International Law, who will be the discussant. Thank you, everyone, for your participation, and we look forward to more webinars coming up. Thank you. See you in 2 weeks. Bye-bye.
Thank you for the invitation. Bye-bye. Thank you.
Bye.